Hello and namaste from India. Just to give a brief introduction about myself, my name is Rajiv Zadhav. I'm a qualified barrister both in England and as well as in India. Currently, I practice as an advocate in the Supreme Court of India and I'm based in New Delhi. I'd like to start the discussion on this topic with what is the International Day for the Elimination of Racial Discrimination all about? To address the significance of this day, I would like to go back in history for a little bit to put focus on a particular law which caused millions of people to fight and sacrifice their lives for democracy and equal human rights for all in South Africa. In the 17th century, the Dutch United East India Company established a colony called the Cape Colony, centered on the Cape of Good Hope in southern Africa. This colony was established to offer a harbor for shipping traveling between Europe and the East Indies. In the year 1760, the law was introduced in the Cape Colony, which was called the Pass Law. And as per the provisions of this law, the slaves, when they were moving between urban and rural areas, they were required to carry passes and produce these passes to the authorities to authorize their travel. This pass law made the police entitled to demand any Africans to show them a properly endorsed document, and if failure to do so, the Africans were subject to arrest by the police. This law hindered their freedom of movement. This also meant that it restricted where they could live, which in turn then tied them to their white employers, underpinning a system of cheap labor and humiliating subjection. As time went by, the implementation of the Pass Law was used for two very contradictory purposes. The white population in South Africa utilized these laws as an exclusionary need to obtain political security by controlling and policing the number of Africans in white areas, and an inclusionary need to ensure a supply of cheap labor within these areas. The legislation and practices associated with the Pass laws have changed over time. As these demands and beliefs change, so did the human rights of the black population in South Africa. When the Pass laws were implemented at the turn of the century, they encouraged the flow of labor into white agriculture and industry and to redistribute labor into geographical areas where it was needed. This process would last until the 1950s, when the government decided to change the paradigm. This meant from 1950 onwards, the emphasis of the Pass laws has been overtly exclusionary and directed to relocating African inhabitants from white community areas and containing them within the place called Bantustans, which is a territory that the National Party administration of South Africa set aside for black inhabitants of South Africa and Southwest Africa as part of its policy of apartheid. Therefore, there has always been a tension between the white community and the black community in South Africa. This stemmed from the efforts to use the Pass system to balance the needs of white community for security and labor, while also creating laws that would allow for the control of African community in terms of employment, housing, access to land and citizenship. Due to these laws, over 17 million African people have been arrested or prosecuted between 1916 and 1984. The policing of African community has allowed for the white community to maintain dominance over the black population for the greater part of the 20th century. As the years passed by, Pass laws would be used less and less to prosecute people. There was a decline in Pass law prosecutions over the period between 1968 and 1981. Which is not surprising considering the new forms of tight controls over arrival or entry of large number of people in one place. There had been a radical change when a commission called Reichert Commission, which was established in response to a crisis faced by the apartheid state, as South African capitalism has been facing its deepest recession since the Second World War. Consequently, the regime was trying to find ways of increasing productivity and profitability for South African industry. In addition, political resistance by the black opposition organizations and the new independent unions increased during the 1970s, particularly after a wave of worker strikes. The government realized that the workers' unions had a certain degree of power and it could not be crushed easily. Therefore, companies and the government had to find a way to allow black community workers to belong to the trade unions, but at the same time ensuring that they did not become a political force. The Reichert Commission recommended that unlawful occupation of accommodation by persons together with unlawful employment would be the grounds for repatriation. Means there would be deportation of someone from the white community area even if they belong from that place. Which meant that they changed their enforcement to being taken off the streets and into housing and factories. Since 1994, 21st March has been commemorated as Human Rights Day in South Africa. The day commemorates the lives of those who died to fight for democracy and equal human rights for all in South Africa during apartheid, which was an institutionally racist system built upon racial discrimination. The day is also observed annually as the International Day for the Elimination of Racial Discrimination. This day is remembered with reference to the Sharpeville Massacre that took place on the 21st March 1960. On this day in 1960, police opened fire at a peaceful demonstration in Sharpeville, South Africa, against the apartheid pass laws, and as a result of this action, 69 people were killed and 180 people were injured. Proclaiming the day in 1966, the United Nations General Assembly called on the international community to redouble its efforts to eliminate all forms of racial discrimination. The United Nations Security Council Resolution number 134, adopted on April 1st, 1960, was passed after a complaint by 29 member states regarding the situation arising out of the large-scale killings of unarmed peaceful demonstrators against racial discrimination and segregation in the Union of South Africa. The Council recognized that the situation was brought about by the policies of the government of the Union of South Africa, and that if these policies continued, they could endanger international peace and security. Eventually, the past laws were repealed in 1986. Sharpeville became the site which was selected by President Nelson Mandela for the signing into law of the Constitution of South Africa on 10th December 1996. In 1998, the Truth and Reconciliation Commission found that the police actions in Sharpeville constituted gross human rights violations in that excessive force was unnecessarily used to stop a gathering of unarmed people. Moving on to the next topic about the day-to-day cases or incidents surrounding the human rights and racial discrimination. I'd like to highlight a recent case in the Supreme Court of India before Justice Dr. D.Y. Chandrachud. The petitioners were advocates and have initiated these proceedings under Article 32 of the Constitution of India. In public interest, for guidelines to be set down to curb acts of discrimination against persons from the northeastern states of India. The petitioners speak of the paradox of secular India, where on the one hand, students from the northeastern states who move to other parts of the country in search of employment and education learn in the process the culture and traditions of the rest of the country, while on the other hand, there is an absence of reciprocating sensitivity towards and awareness of their concerns. They have drawn attention to the discrimination prevalent in society against citizens of the nation drawn from the northeastern states. Such acts of discrimination violate the fundamental duty under Article 51 of the Indian Constitution, which says to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional or sectional diversities, to renounce practices derogatory to the dignity of women. In order to give the factual details, the petitioners have adverted to instances which were reported in the media since 2009. For example, on 26th October 2009, a single woman is alleged to have been burned to death in the kitchen of her home by a stalker whose unwelcome advance she had rejected. On another incident, on 17th April 2012, a young student from Manipur in India is alleged to have died after being assaulted in a hospital. They reported another incident from August 2012, where panic is alleged to have been created amongst a community of persons residing in Karnataka as a result of the circulation of hostile messages on social media. On 29th May 2013, a young Manipuri girl is alleged to have been murdered in a rented apartment in the national capital. In another incident on 25th January 2014, two young women from the northeast were subject to racial taunts and molestation. And soon thereafter, on 29th January 2014, a young student was racially ridiculed and assaulted to death in the Lajpat Nagar area of New Delhi. These instances have been mentioned to not with a view to seeking the intervention of the court in specific cases, but to establish the need for the issuance of guidelines which will bring about a systematic approach to addressing the problem. Moving on to my next point regarding the triumphs we have seen since the International Convention on the Elimination of Racial Discrimination. It is important to mention that after the introduction of this convention, universal human rights have been further elaborated, applying to all regions and continents, while differentiated rights of categories of persons and groups have also been increased rapidly, spurred on by many such similar movements in civil society and by the persistent activism of self-defining groups such as indigenous people. The individual rights framework has been sustained, enriched, and challenged by the growth of collective rights. The official apartheid has been dismantled. The mighty Western colonial system have been reduced to almost nothing. Though international hierarchies have not disappeared and assert themselves in changed geographical environments, people in movement represent an astonishing global phenomenon that contributes to new confirmations of cultural and ethnic diversity. The changes furnish context for the continuing work of the Committee on the Elimination of Racial Discrimination, which in common with sister human rights bodies strive to implement the Convention as a meaningful contribution to the common good in conditions of rapid change in the understanding and reach of increasingly culturalized and diversified human rights. Moving on to my last point regarding what can be done to further the fight for the elimination of racial discrimination. For the purpose of understanding and measuring racial discrimination, race should be viewed as a social construct that evolves over time. Despite measurement problems, data on race and ethnicity are necessary for monitoring and understanding evolving differences and trends in outcomes among groups and the larger population. Many racial and ethnic groups, including Africans, Hispanics, Asians, American, Indians, and others, have historically faced severe discrimination along with pervasive and open denial of civil, social, political, educational, and economic opportunities. Today, large differences in outcomes among racial and ethnic groups continue to exist in employment, income and wealth, housing, education, criminal justice, health, and other areas. Although many factors may contribute to such differences, their size and extent suggest that various forms of discriminatory treatment persist in today's society and serve to undercut the achievement of equal opportunity. In these circumstances, it is critically important to identify where racial discrimination occurs and to measure the extent to which discrimination may contribute to racial and ethnic disparities. A committee on national statistics convened a panel of scholars to consider the definition of racial discrimination, assess current methodologies for measuring it, identify new approaches, and make recommendations about the best broad methodological approaches. Specifically, this panel was asked to carry out the following task: give the policy and scholarly communities new tools for assessing the extent to which discrimination continues to undermine the achievement of equal opportunity by suggesting additional means for measuring discrimination that can be applied not only to the racial question but in other important social arenas as well. Second, conduct a thorough evaluation of current methodologies for measuring discrimination in a wide range of circumstances where it may occur. Third point was to consider how analysis of data from other sources could contribute to finding from research experimentation. And lastly, recommended further research as well as the development of data to complement research studies. I believe these are some of the points that could be taken into consideration to work more towards the elimination of racial discrimination. Thank you. Thank you very much.